Good morning, ladies and gentlemen, and welcome to yet another stimulating presentation. Today, we'll be listening to the head of commercial law, I believe, yes, commercial law, National Open University of Nigeria, in the person of Dr. Ernest Ugbeje. I hope I pronounce it well. Forgive me if I do not. He will be speaking to us about international migration within the context of cash laundering and cash flow. I am paraphrasing his title because I strongly believe that migration in its multidimensional perspective transcend just physical movement of people, but it also involves the movement of cash, as it were. And also what one of my mentors called in his book, Counting the Camels, uh, by late Professor Oguremi. That is another dimension of migration. When you move the camels, somebody has to move them, and all of you. So today we will listen to Dr. Ugbeje, and he has 30 minutes to present and share with us his knowledge. For those of you just joining us, you are free to let us know if you would like to present, and then we do publish, but it is peer review, and we shall announce the editorial board just to tell you how far we've gone. It is composed of distinguished professors, our teachers, our mentors, and it is international by our standard. Dr. Ernest, you have the floor, sir. 30 minutes. Thank you.
Thank you, sir. Good morning, all. Let me start by thanking the management of the university for creating this center that have so much enriched us. And I want to also thank especially the director of the center, Professor Tijani. I only sent him a message via WhatsApp, and that has resulted to today's meeting. I want to thank you for this privilege. I want to also welcome everyone, my senior, Professor Emeritus, other professors, and my other senior colleagues and fellow colleagues to this presentation. As you heard rightly, the title of my presentation today is Laundering of Proceeds of Corruption through International Migration in Nigeria, the Legal and Enforcement Imperative. The abstract is there. It's a concise summary of what I have in the paper, detailing the method, the findings, and the recommendation therein. Today's presentation will follow this order. We'll be looking at introduction, conceptual clarification, nexus between corruption and money laundering, nexus between laundering of proceeds of corruption and international migration, legal framework on anti-laundering of proceeds of corruption, gaps in the legal enforcement regime on anti-laundering of proceeds of corruption, legal and enforcement imperative. Before we go into it, the first one is the introduction. We have about 7 items to look at. We'll look at the introduction. Laundering of proceeds of corruption is a major obstacle to development and has become increasingly source of concern for developing countries, Nigeria inclusive. The reason is that every year, a massive volume of capital is illegally and illicitly transported out of developing countries into tax havens and the financial centers of the world. In fact, it's estimated that 420 billion of capital was transferred out of Africa, predominantly to major economies of the world. More recent, for instance, between 1980 to 2009, it was estimated that between 597 billion to 14 trillion left Africa to these other countries. And within this period, what happened in Nigeria? Nigeria was not excluded. Nigeria was a major source country for illicit financial transfer out of Africa, and it's estimated over 217.7 billion loss to illicit financial flow. So it was not surprising that as of 2010, Africa was a net creditor of the world to the tune of 1.4 trillion naira. These findings were reiterated even in 2015 by African Union's high-level panel on illicit financial flows from Africa, which estimated that illicit financial flows from Africa could amount to 50 billion US dollar per year. And this will double the inflow in terms of financial assistance that comes into Africa within the same period. There is this report by Global Financial Integrity. It estimates that illicit outflow from developing countries range from 620 billion US dollar to 970 billion in 2014 alone. And when you compare it to the inflow into Africa within that period, which is 137.2 billion naira, you find out that what is going out of Africa is far cry from what is coming into Africa. And more recent report by the same Global Financial Integrity report shows that between 2004 to 2013, Nigeria surpassed South Africa as the country with largest average illicit financial outflow in Africa. There are so many other reports. For instance, the report by Hunter, the study on misinvoicing of primary commodities shows that export misinvoicing is a major channel of capital transfer out of Nigeria. The challenge of illicit financial flow persists in Nigeria. Now, there are growing bodies of literature that paint an alarming picture of the magnitude of these illicit capital flows between Africa and other parts of the world. The impact of the laundering of proceeds of corruption in Nigeria is visible, and all of us can see it even as we walk across the street. This debilitating effect, far-reaching effect, is by far the greatest challenge confronting us as a nation today. We have seen so many panels being held in the National Assembly. We have the NDDC, we saw the figures that are being called, and we know the state of development in that region. While nations of the world are facing the challenge of coronavirus, as also known as COVID-19, Nigeria's topmost challenge appears to be corruption virus. According to PW report, the report that corruption in Nigeria could cost up to 37% of gross domestic product by 2030 if not checked. This cost is equated to around costing an individual $1,000 by 2014, and it will escalate to $22,000 per person by 2020. So the real and the opportunity cost of corruption and laundering of these proceeds is immeasurable in Nigeria. The gravity of the situation has been one of the reasons for gradual improvement in the intake of strategies against laundering. Corruption and laundering of these proceeds is a major push factor for international migration. Many young Nigerians are leaving Nigeria because of the present state of development occasioned by ravaging corruption in the country. In 2016, over 20,000 young Nigerians were involved in crossing of the Mediterranean Sea. Another report shows that over 15 million Nigerians are in diaspora, remitting over 25 billion, representing 6.1% of our gross domestic product, a figure that translates to 83% of federal government budget in that year. That notwithstanding, the actual amount of the remittance flow into the country is arguably higher because of unrecorded transaction via informal channels of remittance. That notwithstanding, IMM has been linked, that is, international migration has been linked as one of the channels of laundering of proceeds of corruption. Therefore, this research using doctrinal, case study, and comparative approaches examines the role of international migration in laundering of proceeds of corruption in Nigeria. To address this set aim in this paper, the following questions will be addressed. One, what nexus exists between corruption and laundering of proceeds of corruption? Another one is what nexus exists between laundering of proceeds of corruption and international migration on the second part. Now, is there a legal framework on anti-laundering of proceeds of corruption in Nigeria? What gap exists in the legal and enforcement regime in anti-laundering proceeds of corruption in Nigeria? And what are the legal and enforcement imperatives? We take them in turns. But before we do that, let's undertake conceptual clarifications of some key concepts. We'll examine just three of them. We'll look at the meaning of proceeds of corruption, international migration, and the meaning of money laundering or money laundering. The first concept that we need to clarify is the concept of proceeds of corruption. What does it mean when we talk about proceeds of corruption? United Nations Convention Against Corruption also known as UNCAC, defines process of corruption as any property derived or obtained directly or indirectly through the commission of an act, through the commission of an offense. In this context, we are looking at the offense of corruption. One key word that requires clarification in that definition is the meaning of property. What does property mean? That same UNCAC offer a clarity to what property entails. Property is not limited to money, it's not limited to land alone. He said property shall mean assets of every kind, whether corporeal or incorporeal, movable or immovable, tangible or intangible, legal document, instrument evidencing title to or interest in such assets. But I am more at home with the definition by the African Union Convention on Preventing and Combating Corruption, known as AUCPC. It defines process of corruption to mean assets of any kind, corporeal or incorporeal, movable or immovable, tangible or intangible, any document or legal instrument evidencing title or interest in such assets acquired as a result of acts of corruption. That one was very explicit about the source of the proceeds, in line with the title of today's presentation. So the definition above shows clearly that process of corruption is not limited to money alone. It includes other properties and even in their converted forms. Now, another concept that we need to clarify is the concept of international migration. Migration study is reading with binaries, and in dissecting these binaries, Kings, Skedon, and Venetari noted that in this binary, such as forced versus voluntary, temporary versus permanent, legal versus illegal, it was noted by them that internal and international migration is one that stands out as the most fundamental verification. Then, international migration is used in contrast to internal migration. What then is internal migration? Internal migration is the movement of people within a state involving the establishment of new temporary or permanent residence. Then, on the other hand, international migration will be the opposite of internal migration, and it means the movement of persons away from their place of usual residence across an international border, to a country of which they are not nationals. I highlighted the country of which they are not national because that will raise the issue of people having dual citizenship, where they move the proceed from one, or they move from one country to another, that not be regarded as international migration. Therefore, in this paper, international migration is the temporary or permanent movement of person away from this place of usual residence and across an international border to another country. Where that is their place of second citizenship, it is immaterial to this presentation. Now, the third concept that we are clarifying is laundering or money laundering. Laundering is a generic term used to describe the process by which criminals disguise the original ownership or control of proceeds of criminal conduct by making such proceeds appear to have been derived from a legitimate source. Another definition is that it is any act or attempted act to conceal or disguise the identity of illegally obtained proceeds so that they appear to have originated from legitimate sources. That was given by Interpol General Assembly in 1995. So from above, you will see that laundering or money laundering is a middle crime in the chain of crime commission. It is used to hide the proceeds of corruption or triggers commission of further crime. Traditionally, all laundering cases passes through 3 stages. The first stage is the stage called placement, and that is where the illicit property is introduced into the financial system. The second stage is the layering stage. That is the substantive stage. That is where the disguisement, the concealment, everything takes place. That stage where the illicit property is washed to make it appear clean via disguisement and concealment. The third is the integration. Integration is the final stage where the laundered and washed property is reintroduced into the legitimate economy. Now, what is the definition of money laundering under our Money Laundering Prohibition Act of 2011? That act defines money laundering when a person in or outside Nigeria directly or indirectly conceals or disguises the origin of, converts or transfers, removes from the jurisdiction, acquires, uses, retains, takes possession of control, any fund or property. Any fund or property. Remember that we said earlier, that process of corruption is not limited to fund alone. It includes property. Knowing there is a place of knowledge or where it should be reasonably suspected to have known that such fund or property is or form part of process of unlawful act. The yardstick must be an unlawful act that is being conceived, the process of unlawful act. So the act also criminalizes, provides punishment for corporate bodies, and the punishment upon them extends to 100% of the fund or property being seized by the government. It also extends to revocation of the license of such corporation, talking about companies. So there are other acts that qualifies as laundering, and that will include where a person is in possession or pays a cash exceeding 5 million naira. And for corporation, where a corporation pays a cash exceeding 10 million naira, that will fall within the definition of money laundering under the Money Laundering Act of Nigeria. So the Act also provides that any individual who is transporting cash or negotiable instrument, there is need for exceeding 10,000 US dollars, there is need for disclosure. And where there is failure of disclosure or false declaration, that amount to an offense and is punishable. And upon conviction, the total amount will be forfeited, or the amount will be forfeited in conjunction to imposition of 2 years imprisonment. So one of the questions raised earlier was to establish what nexus exists between corruption and money laundering. And according to Gorodema, he noted that the links between corruption and money laundering can hardly be contested. Why? Because money laundering remains one of the main channels of laundering of process of corruption. So there is a nexus between them. While corruption is one of the predicate offenses of money laundering, the movement and concealment of the process of corruption is made possible through money laundering. So money laundering is a crime only insofar the underlying act generating the proceeds. In this context, we talk about corruption is a crime in the jurisdiction. So corruption is a crime. We have offered a definition by Transparency International regarding definition of corruption, which means an abuse of a trusted power for private gain. And broadly, when we look at corruption, we classify it into grand corruption and petty corruption. Laundering or process of corruption relates more to grand corruption, because that is, according to Rosakama, grand corruption involves a small number of powerful persons, and these persons are referred to politically exposed persons, and but involves large sum of money. And it is this movement of this large sum of money that is impacting on the development of Nigeria. Grand corruption is a major predicate offense of money laundering. However, it can also be used for other forms of corrupt practices. In this presentation, our focus is on grand corruption. And it's not surprising that even in 2015, the Global Financial Integrity estimated that approximately 5% of global financial flows came from corruption. The same report was also given concerning Africa. Therefore, there is a symbiotic relationship between corruption and money laundering. They feed on each other. So the established nexus between money laundering, as shown above, and corruption, as shown above, necessitated the need for criminalizing laundering of processes of corruption as one of the related offenses of corruption. So laundering of processes of corruption under the various conventions is regarded as a related offense of corruption. So there is another estimate given by one researcher as to the magnitude of the loss occasioned by laundering of processes of corruption. So there is a clear nexus between corruption and laundering of corruption. Now, what is the nexus between laundering of processes of corruption and international migration? In addressing the question whether international migration facilitates laundering of processes of corruption, the research analyzes the following cases in Nigeria to decide to determine the existence of elements of international migration. The following cases were examined. We look at first the case of Sani Abacha. After his death, above 5 billion US dollars was reportedly laundered, and these monies were kept in banks in Europe. Mr. Abubakar Bagudu was in the United States facilitating the laundering for the state, for the late head of state. And we also see the involvement, the incorporation, the company known as Dura Buy Property, a shell company set up by same Mr. Bagudu to primarily launder funds stolen from Nigeria within that period. And what happened was that he was arrested in the United States over this laundering, and quickly was smart enough to enter, repatriated to Nigeria to face trial, but that never happened. But what we saw was that instead of being prosecuted in Nigeria, we have him being elected as senator and presently serving as a governor. Then other cases, we have the Lemesea case. He used companies registered United Kingdom, South Africa, Seychelles, British Virgin Islands, and Bahamas to launder the proceeds of corruption. He had residence has a house in London, and over 1.5 million in cash was seized from his London home. The Bori case also presents a very fascinating case in support of IM, that is International Migration Supporting Laundering of Proceeds of Corruption. We have his mistress, we have his wife, we have even his legal counsel over there in London facilitating the laundering of proceeds from Nigeria. Now we have another case, that of concerning a former defense minister, Musiliu Obanikoro, who after 2015 election flew to US where he is a citizen to avoid answering various allegations, but he was smart enough, he returned to Nigeria, entered into a plea bargain with them, and is now a star witness for the prosecution of former governor of Ekiti State. Now we have Mohamed Bello Adoke. He had an allegation of money laundering against him over $6 million US. He left Nigeria for postgraduate study in the Netherlands after 2019 general election, but never returned after the completion of the study. EFCC, why the Attorney General office believed that he had no case to answer, EFCC thought otherwise and pressed for extradition. They were able to obtain an order in Nigeria, but before he could be apprehended, when he arrived in Dubai, the order had already been vacated in Nigeria. So the Interpol, following the red alert that was issued by following the request by EFCC, so he was left off the hook, but he returned back to Nigeria and is presently facing trial. Another interesting case is that of Desiani Edison Maduekwe. He was the former Minister of Petroleum who had both UK and Dominican citizenship. He is presently indicted for money laundering. He fled from Nigeria immediately after 2015 presidential election amidst allegations of corruption against her. The Dominican granted her a diplomatic passport and made her trade and investment commissioner, an appointment which conferred on her a protective shield from arrest by anybody. Therefore, effort at extraditing her to Nigeria to face charges of corrupt practices have not yielded positive results. The above case analysis revealed that international migration facilitated laundering of proceeds of corruption in Nigeria. So what are the legal framework on anti-laundering of proceeds of corruption? We have plethora of them, we have so many of them. We have UNCAC, Nigeria signed to it. We have AU, CPC, Nigeria is also a signatory. We have FATS recommendation. It has up to 40 plus special recommendations on international standard on combating money laundering. We have other organizations that Nigeria has joined, Edmond Group of FIA. We have Interpol, Nigeria is also working with them. The Constitution of the Federal Republic of Nigeria, Section 15, Section 5, also provides that states shall abolish all forms of practices, corruption of corrupt practices, and abuse of power, and that includes laundering of proceeds of corruption. Money Laundering Prohibition Act, that is the main law criminalizing money laundering in Nigeria. EFCC Act also establishes EFCC and also gives EFCC power to implement provision of money laundering acts. And ICPC Act criminalizing corrupt practices, which is the predicate offense for the commission of money laundering offense. We have a Nigeria Financial Intelligence Unit Act that was enacted in 2018 that establishes Nigeria Financial Intelligence Unit as an autonomous body, and they have three main roles, which involve receiving, analyzing, and disseminating of financial intelligence to end users. We have Extradition Act, have Mutual Legal Assistance Act. There are other sectorial laws like NATI Act, Anti-Money Laundering Policy, the Treasury Single Account, IPPIS, BVN. They are all governmental policy aimed at regulating and preventing money laundering in Nigeria. There are other, including due diligence by CBN to bank and KYC, know your customer, that is policy requirement by the CBN on commercial bank to ensure that effective monitoring of movement of funds from their customers and easy tracing of such persons. Now, legal and enforcement gaps. We have identified some of the laws approved. What are the gaps in these laws? One of the gaps identified is that discretionary provision of UNCAC. UNCAC uses the word may, and in that convention was rightly regarded as a termite. It weakens the convention because such provision weakens the potency of the convention. Now, there is provision under the Constitution on immunity. that forbids the prosecution of president, vice president, governor, and deputy governor of any crime while in office. And you recall, if you cast your mind back to some of the cases analyzed, most of them are past governors. Most of them were, during the time they were in office, they enjoyed immunity. That means no action could have been instituted against them, even though they could have been investigated. Even when you have clear evidence against them, the provision, Section 308, forbids you from pressing any court charges against them. Now, but that is contrary to what Nigeria signed in African Union Convention Preventing and Combating Corruption. Article 7.5 specifically provides that any immunity granted to public officials shall not be an obstacle to investigation of such person as well as the prosecution of that person. Another section under the Constitution that is also of concern is Section 171 of the Constitution. It empowers the President to appoint the head of any of the anti-corruption agency in acting capacity. We saw that played out in the appointment of Ibrahim Madu, the former EFCC chairman. And what happened is that it gives the President unfettered control over such head of anti-corruption agency and also weakens that institution. Why is discretionary power given to the Attorney General of the Federation in prosecution and withdrawing of any case under the principle of non-prosecute is another constraint that is hindering the efficacy of enforcement of anti-money laundering measures. Now we have Section 3, Subsection 2 of EFCC Act that empowers the President for misconduct or that provide that if the President is satisfied that it is not in the interest of the Commission or the interest of public that the member should continue in office, to remove such member, including the head. And we saw that played out in Nigeria history, starting from Waziri, Lamode. Now we have seen it also happen to Ibrahim Magu. And the implication of that is that it weakens the institution. It subjects such head of anti-corruption agency to the wills and caprices of the person appointing and removing him or her. So, enforcement gap. The research groups the enforcement gap into three failures. And the first is the failure of governance, failure of institution, and failure of the people. Under the failure of governance should be a system that should provide and protect the welfare of the citizen, including provision of jobs and also reducing high-level poverty in the country. But that has not been the case in Nigeria. There has been a largely failure of government to meet this requirement. As a result of that, there is a huge deficit between government and the governed. And another aspect is that there is failure of the government to provide effective social security, housing, pension, health insurance scheme that will reduce the incentive for corruption and laundering of corruption in Nigeria. There is also weak political will under this governance. This one is applicable not to Nigeria, even to the international community. There is high hypocrisy. A research by one of the scholars in this area of money laundering called Sharma regarding OECD member states. He found out that even the developed countries are more in breach of international standards on anti-money laundering rather than us, developing countries where the money is being moved to. So you can see that in their visa and investment policy. In their visa, for instance, we take of that of UK, there is one calling you to have, I think, about 50,000 pounds that will give you access to residency. The source of that fund is not really a question because they are just concerned about attracting money to that area. There is unrealistic minimum wage, not the living wage. When you compare what is being earned to the minimum wage of 18,000, we discover that Nigerians are earning below 18,000 as we speak. Failure to secure the welfare of the people, provision of basic amenities, these are all incentives are pushing people to even engage in corrupt practices and laundering of such practices, and has led to what I regard as primitive accumulation of wealth because people don't feel that their future is secure. So they are now grabbing even for the one that their generation unborn cannot spend. So the relevant failure of the institution, we're looking at the gaps, failure of the institution is another one. We have the relevant institution in this area. We look at the anti-corruption agency, we look at the judiciary, and also look at the anti-corruption and the Attorney General's office. Now, under the anti-corruption agency, we find out that the power of the president to appoint, as noted earlier, the chairman of this anti-corruption agency is weakening their operation. And there is also lack of physical autonomy of Nigeria Financial Intelligence Unit. And investigative challenge is another issue that was clearly manifested in the Boris case. In that case, hello?
You have 1 minute,
Okay.
please.
Okay. The issue of technicality is another challenge. Now, the failure of the people. The people have failed to demand for accountability, condoning the corrupt person, wrong mindset as to accumulation of wealth. Source of wealth is no longer an issue, and people are now being honored on a grant of the amount they have without questioning the source of such funds. So I have made what are the legal and enforcement imperatives. Under the legal imperatives, I've recommended that the discretionary provision under the various conventions be made mandatory for state parties. If I can be given 2 minutes to be able to round up, there should be elevation of the offense of grand corruption under UNCAG as a crime against humanity. And one woman has also canvassed, a scholar has canvassed for such elevation so that anyone can bring a nation against corrupt person in any part of the world. Section 308 on immunity, I've canvassed that the interpretation of the Supreme Court regarding election petition, wherein the court held that the incumbent governor, when the issue of immunity was brought, the court held that the governor is, since what is in issue is the right to remain in office, that immunity should not be applied. That can also be extended to grand corruption cases where there is a glaring evidence. The court can also hold that such is affecting the right of such person to remain in an office. So section 171 also, I've also recommended for the amendment, limiting the appointment of that acting capacity of head of anti-corruption agencies to just 1 year, And section 17 also, section 3.2, I've also recommended for recommendation. Enforcement imperative, what must be done to improve the enforcement? That is turning the 3 F's to 3 successes, and that will require us attaining success in governance, and that will mean having effective health, housing, pension scheme, having a living wage, not a minimum wage that is not commensurate to what is at pay, the present reality in the economy. We have also asked for the international community to show strong commitment to the fight against laundering of proceeds of corruption. I said that the above will remove the incentive for corruption and laundering of its proceeds. And I've also called in terms of institution that the institution should be strengthened by guaranteeing their independence, and the amendment and the step that should be taken. We have also highlighted the separation of Attorney General's office from that of the Minister of Justice, and also recommended the procedure for the appointment of Attorney General. Now, success of turning the failure of the people into success. Citizens should demand accountability from the government and their elected officer. Nigeria should stop condoling and protecting peps that are found to be corrupt. Entrenchment of right mindset, and through a massive education, Nigeria must realize and accept that success in preventing and combating laundering of proceeds of corruption in Nigeria can only be fought and won by us alone. Reliance of external help will not help us in this regard. The culture of it is our time to eat from national cake, whenever a kinsman is elected to appointed public office, should be jettisoned. Nigeria should name and shame corrupt person. Thank you for listening.
Thank you very much, Dr. Ernest. I don't know how you will ensure that when your kinsman becomes the governor of Delta State, how you will. My apologies because I've been in and out since I'm operating from my cell phone. My iPad just refused to allow me to sign in. I'm aware that the last time Professor Abdallah Ubadamu noted he would like to make a comment. I'm not too sure of any other person. If you are interested in asking question or comment, kindly, okay, then you will be followed by, I don't know whether it is Dr. or Professor Adedakbo, and then Dr. Rosemary Saibu. I can see your hand. So I'm taking it in that order. Professor Abdallah Ubadamu, Dr. or Professor Adedakbo, that is Adeyemi Adedakbo, then Dr. Rosemary Saibu. Let me scroll down and see whether I have one more or two. Dr. Arie, Gloria, okay, you'll be followed. And I think I will take those for now until I see someone else. Dr. Adedapo, you can please lower your hand. We open the floor with the comment or question of Professor Uba Adamu. And let me see, I have to unmute some of you, I guess, I have to unmute you. Okay. Ask to unmute. Please kindly unmute yourself. Go
Okay,
ahead.
good morning. Yeah, good morning, everyone. It's good to be here again, as usual. I think we are losing sight of one fundamental objective of this particular center. And I just want to remind us and also remind Professor Hakim Tijani of the need to remind people that this is a center for migration and global studies, two concepts. What I have seen so far is that we try to force the word migration on everything that we do, even if it doesn't fit in. Just because we want to be able to say that this is a migrant. Rosemary, lower your volume. Just because we want to be able to say that we have participated in a migration lecture. Let's not lose sight of the fact that we're also dealing with global issues, global studies that are not necessarily focused on migration. And an example of a paper that muddles things up, I'm very sorry to say, is this particular paper presented by Ernest. And he's forcing the word migration into the narrative, even though it does not fit in, but he has to put it in. Because 95% of the paper is all about corruption, about legality, and so on and so forth. All those people who have run away from Nigeria because they have stolen money have come back, so they're not migrants. So what's the difference between somebody who is running away from prosecution because he's a criminal and somebody who decides, I'm tired of this place, I'm moving to another place and getting a citizenship, permanent citizenship for the other place? That is a migrant. You move out of here, you go to another place, with the intention of becoming a citizen and swearing allegiance to that particular place and not wanting to come back. But all you have done so far is talk to us about how people steal money and the amount of money that they have stolen, which is okay. It's part, like I said, it's part of global studies, but not necessarily migration. I mean, money doesn't migrate, it flows. So you can't talk about money being migrated, but it flows. It goes from one place to another. And the fact that some of these people who were criminals and they have done criminal activities in taking out our money to other countries have now come back and are occupying critical position. Bagudu, over the guy you talked about, who is Abacha's drone in the United States, was arrested or something like that, is now the governor of one of the states in the north. So you see the problem is he's not a migrant. He was a criminal. He ran away to do something and now he has come back. And he has even been glorified by being elected as a governor, or he purchased his way to the government house so that he became a governor because of the money that he also stole from those who stole. So he's stealing from the stealer. So I really don't see migration here. Dezani had a UK citizenship, so she could be a migrant. But migrant to where? To Nigeria or Dominican Republic or to the UK? Because she was in the UK and she has a UK citizenship, so she's a migrant. But she decided to come to Nigeria, steal some money, and then run off again. And then now she's in another country and she's also another migrant there, and she has another citizenship. So what's the difference between the citizenship that you purchase because you are corrupt, like Dominican Republic, Barbados, and all those places, and the citizenship that you acquire as a result of having stayed in a place and swearing an allegiance to that particular place? So I think your presentation falls under the rubric of global studies or something like that. And also you're talking about 5 million naira being the maximum that somebody can take out. Yes, that's not money laundering. I'm leaving the country, I'm checking out. I have sold all my property, I've sold everything, and it is worth about 5 million naira. So long as I declare it at the customs and declare that I'm selling everything. I mean, $10,000 is the maximum amount you can take out without, but you have to declare it. So long as I declare, this is the money that I have sold my house, sold my car, have even sold my wife and sold my children, and I've got all the money. And based on that, now I want to get the hell out of this country. I want to move to another country. So I declare it at the custom office. I don't think that I'm money laundering, because I can legitimately explain why or how I got that money. So finally, because I know a lot of other people are also talking, you are trying to link corruption with migration. And I am saying, I don't agree. because you have insufficient data to show that the motives of people who migrate is because of corruption. We don't have that data. I mean, a guy from Edo State who decides to migrate out of Nigeria to go to Italy and become a mechanic is not necessarily money laundering or anything. But then at the same time, there is some contradiction in some of the data. You talk about outflow of money as laundering. But then also, that is where we have surpassed South Africa. But then also about inflow of money, about something like $6 billion that we are sending back to Nigeria. So I don't get it. I mean, are we corrupt or not? We're taking money out and we're taking money, bringing money back in. And I'm migrating out of Nigeria because I'm tired of the country. I'm sick and tired of increasing fuel, increasing this, increasing that. So I've sold everything. Like I said, I've even sold the dog. I don't want it. You know, the cat, I don't want it. Sold everything. And the whole lot, my entire net worth is something like $30 million, okay? $30,000. And I go to Namdi Azikiwe Airport and they say, declare, what have you got? I said, I've got about $30,000. Oh, and then they come out with guns, all their Glocks and their AK-47 trained on me because I'm a thief. I said, no, I've got receipts. I've sold everything. I'm getting out of the country. I've got a citizenship somewhere. That's not money laundering. I'm just simply checking out. So I think there is a need, Professor Tijani and all of us don't try to force migration into the narrative. But remember also, we are dealing with global studies. So we could also see things apart from global platform of corruption, for instance, the legal frameworks for corruption, Transparency International Index and all that. So once we do that, I think we'll keep it a little bit more lively because I think because of our Bekule Tijani is trying to, he's the director of a center, so everybody wants to please him, and therefore everybody has to say migration, migration, migration in the word. I mean, I've seen migration in Bible, I've seen migration in law, I've seen migration in everything else. So that's all I have to say. Thank you very much, and good show.
Hello, good morning.
Good morning.
Good morning. The host, my professor, and everyone. Mine is not a question, but just an observation. Going by the title of the work, to me, I think it should be a position paper, not a empirical paper. Because when the presenter was presenting, I could see something like a research question or so. So that research question could have been the objectives of the paper, because there is nothing like analysis of a result there. So I think that that paper could have been a position paper instead of an empirical one. So I still want to learn. So thank you. That's what I have for now. Thank you, sir.
Professor Tijani, I'm not sure it's still connected. Dr. Ori. But I think other persons should ask their question, please. Okay. I think he's having challenge with connection. Let me address some of the issues raised. Two concern from our able Vice Chancellor. He has raised some issues concerning the scope and the relationship between.
Oh boy. Can you just keep flowing? I'm going to unmute everybody because my internet access is going in and out. I believe we've listened to Professor Adamu. I unmuted the next person. Please just let us keep flowing. And Dr. Ernest, if I'm in and out again, just note those people that were supposed to, you are the co-host. Can you hear me?
I'm hearing you, please.
Okay.
Dr.
I want
Rosemary is raising her hand. Dr. Rosemary Saibu is raising her hand.
Rosemary, I've unmuted her. I'll unmute all of you that are supposed to speak. And Dr. Ernest, you too can do that because you are a co-host. Okay? Amede Lucky, I believe I asked you to unmute.
I've unmuted Dr. Rosemary.
Please go ahead. Dr. Saibu, go ahead, please.
Yeah. Good morning, House. I want to commend our Vice Chancellor for this great opportunity, for even this very presentation from time to time.
Students are making a lot of
Very,
noise.
very important. The number today is so low. It's important we lecturers take this great opportunity to be attending this seminar. I want to commend the effort of Dr. Ernest for the presentation. It was a very good presentation and also well presented. But my worry is about the issue of Section 3 of EFCC Act, which says that they protect the heads of the agency. Why? For instance, now, the former chairman of EFCC embezzled their money. And even the issue that those in government, like the president, the vice, the governor, and the vice governors, that they should not be called into order while they're in the government. I think the law should be amended. Anybody that does anything wrong should be cautioned. And the issue that things happen in the country
Sorry, I think the audio from Dr. Saidu is kind of bad. Dr. Saidu, we cannot hear you. Dr. Saidu, can you just test your comment, please? Can be. Dr. Adimula, you can take over.
Hello. Hello.
Dr. Adimula, take over, please. Go ahead. Okay, Dr. Adedapo, can we listen to you now? You're on mute.
Hello, sir.
Hello?
Hello, sir.
Please go ahead, please.
Okay, sir. Mine is not a question per se, but just an observation. I appreciate the host, Vice Chancellor, and the presenter, and everyone. Because when I look at the topic, the title of this work, it looks like a theoretical one, not empirical. When the presenter was presenting, I could see something like research questions. So I'm saying that is it an I'm seeing the presenter now, is it an empirical paper or a position paper?
Okay. Thank you very much. Thank you very much. Thank you. We can hear you.
Because I believe that you know, with a position paper, we can come up with a research, the objectives of the paper, not even a research question, because I could not see anywhere.
Okay. Thank you.
The results of these, the results were presented. So that is just what.
Thank you very much.
Okay, sir.
The author notes that, and he will respond shortly. Thank you. Please ask you to mute. Can we listen to Dr. Ademola, if you are still there? And then next we will take Dr. Amede. I've asked you to unmute yourself.
Yes. Good morning,
Hello.
sir.
Thank you very much.
Okay,
This
ma'am.
is
Thank
Dr.
you.
Adimola. Can you hear me?
We can hear you, ma'am.
Okay. This is Dr. Adimola. I want to commend the presenter for good presentation and a very rich paper. My observation is actually in one of the recommendations, particularly in respect of separating the Office of Attorney General from the Honorable Minister, because they are dual responsibilities. While one is professional, that is Attorney General, and the Office of the Minister is political. I see that this recommendation particularly has become more of a style to almost all legal presentations that has to do with corruption than taking action. For almost 30 years that I've been a lawyer, I've had this recommendation said in several MBA meetings, conferences, NEC meetings, and everywhere. Separate the Office of Attorney General from the Office of Minister of Justice. But up till now, I don't think any step has been taken. Unfortunately, even the senior lawyers, the SAN, that are proposing it in MBA meetings, when they get to that position, they enjoy it. They don't want it separated. And so this is an academic exercise that we are doing here. And I believe that such recommendations cannot just come like that without giving rooms, suggestions, and ways that it can be implemented. Because these observations, recommendations, particularly in this area, is always there for decades. Even before I became a lawyer, it has always been there. But how do we do it? How do we take steps to ensure that the federal government, the executive arm of the government, separate it? It is not sufficient to just put it in our papers and make it as recommendation. Everybody is recommending it at all levels, even people that are not in the academics. And it is always been said. How do we take step? Who is going to initiate it? Who is going to pursue it? Who is going to ensure that it is done? And I believe that the presenter should also look into this. We should do more than ordinary lawyers on the street. Thank you.
Okay. Thank you very much, our colleague from University of Illinois, and being a regular one. We've listened to comments and questions from the lawyers that are with us today. And those of us that are much more learned, that are not lawyers, you've also comments from them. Let me have, of course, I asked the question before we started, and I will not go back to those that I mentioned, but let me say this. Is cash flow, whether in or out, can we say it is a form of migration? We can look at it from the global context, fine, but does it really fit into, migration? That is to piggyback on Professor Abdallah Adamu's comment. Also, a presentation or a research paper, whether empirical or theoretical or whatever you want to classify it, I believe should take note of the following. One, what is the state of knowledge? What exactly do I plan to contribute to knowledge? Okay, those two key comments I believe are important. What exactly do you plan to? Is this an original work? Is it something that you want to pass and then critically? That also fits into the last comment asking you about being empirical or theoretical. Lastly, may I suggest that if you have not seen a book titled International Migration, I've forgotten the other part of the title, but of course, one of the authors is one of us at now, Dr. Udochi, and Mr. Shaibu Makonjola. Udochi is the HOD of political science. You may want to pick up their work on international migration. I think that, you know, they kind of analyze some of the issues you raised here. Having said that, let's allow you to speak, respond to this comment so that we can round up at exactly 12. Apologies for the in and out. I'm actually reaching out on my way to Calabar for monitoring assignment. So, but that is not an excuse. My apologies. I have to get in touch and start this on my cell phone. Thank you very much. Dr. Ernest, you can respond, please.
Thank you, Prof. I think I'll start from the comment by our able Vice Chancellor. I take the
There's
hint.
no Vice Chancellor. He has told you that.
Okay, Professor. Okay, the first observation made by him was regarding the scope, whether the workforce within migration studies. I believe and strongly so that even from my presentation, I was able to establish that link between migration and global studies. I made it clear that the focus of the paper is to determine whether international migration facilitates laundering or proceeds of corruption. That was the focus of the paper. And it was this aim that formed the basis of the research questions that was examined. And that the questions were clearly answered throughout the whole paper. It may not have been as detailed as you wanted because a PowerPoint presentation, some things are not included here. And there is a strong link. I established the nexus between corruption and laundering of proceeds of corruption and international migration. And case studies were used, real life case studies, cases that were examined to show that international migration facilitated or still facilitates laundering of proceeds of corruption. We must not lose focus of that aim of the paper. And thereafter, I examined the legal frameworks. There is nothing that forbids anyone. I've not seen it anywhere, whether you're writing a position paper or you're writing a theoretical paper, that forbids you from raising any research question. We are learning. If there is that, I can also take it away. We have most of our writing in legal writing are theoretical. You can raise questions, provided you are able to address the questions you raise. That is to address the concern raised by the first and the third, the fourth person, Dr. Adeyemi, and the second speaker. There is another it was a comment by Dr. Rosemary, and he talked about section 3, subsection 2, the detailed recommendation, what you said contained in the paper, and also separating the Office of Attorney General, the detailed strategy to be used are also contained in the paper. Maybe when the paper is out, you'll be able to see. In all, I want to emphasize that there is a nexus, there is a link between laundering of proceeds of corruption and international migration. We saw cases, they all left. That is why I clearly defined the scope, clearly conceptualized the meaning of international migration, whether it's temporarily, whether it's even via students going there to study, provided you have left your habitual place of residence to another place, the duration notwithstanding. During that period, were you used to launder proceeds of corruption, or did you take that step to launder proceeds of corruption? That was the whole essence of the paper. And at the end of the day, I was able to, the research finds that international migration facilitated and still facilitates laundering of proceeding. We looked at the legal regime, we identified gaps in the legal and enforcement regime, and on the basis of the gaps identified, we made a far-reaching recommendation. Thank you so much, sir.
Thank you very much. Thank you very much, Dr. Ernest. I thank each and every one of you for being with us today, despite our various schedule, particularly the examination. And for those of us in transit monitoring station, I wish everyone speak very much. Say bye-bye to all of you.
Thank you.
Thank you.